Welcome, everybody, to the Radical Moderate. I am your host, Pat O'Brien, and today I am joined by civil rights attorney Dave O'Brien. Dave, welcome to the show.
Thank you.
So for those wondering, we share the same last name, and that is because we are actually first cousins. We don't hold that against each other. We get along just fine. But Dave, I wanted to have you on today specifically because of your specialty, which is use of force cases involving law enforcement. So if you would just give the audience a little bit of your background, like how much do you know about the topic, et cetera?
Well, it's my area of expertise in the law. It's essentially the only types of cases I handle. I work pretty much exclusively in the state of Iowa, and I do excessive force cases against police officers and some related type of matters. It's a highly specialized field of law, and I've been doing it for about 20 years, and it's all I do anymore.
Wow. Well, when we first talked about doing a podcast, and we will get to this, but we talked about just doing kind of what you do for a living in general, do the cases you have and how it all works. But then in January of 2026, we had two deaths, one of Renee Good, the other of Alex Preddy. And these are things that I bet every American pretty much has seen the videos on these and probably has formed an opinion. And I said, well, I got a go-to guest for this. So if you would, I don't know how you want to frame it. I don't know where you want to start, but these two cases, give us some context here. How does all this stuff work from a legal perspective? And just start telling us what all is involved and what would we expect to happen next in these cases?
Well, you got to remember that we're talking about civil claims. From what I do, I don't have any control over the criminal justice system. That's up to prosecutors. And because the cases in Minneapolis, the Good case and the Preddy case, involve federal law enforcement officers, that would be potentially a Bivens claim which is the name of a Supreme Court case that allows federal claims to be brought under a particular code section. These are generally referred to as 1983 cases. That's not a year. It's 42 USC 1983 is the code section. And then the Bivens case allows these claims to be brought against federal officers. And that's where it all starts. You look at whether you got a federal claim or not, and then you're looking at potential related state claims. Obviously, typically assaulting and killing someone without justification in most states that I'm aware of is a violation of civil law. And you can bring those claims civilly, but you're not doing anything from a criminal perspective. That's entirely up to prosecutors.
So, yeah, and that's a great point. And we might, during the podcast, touch on potentially like what could happen, if anything, in a criminal matter. But let's go with what is publicly available evidence. Certainly the video footage is publicly available, but nobody's trying to do a rush to judgment. We weren't there. There's going to be witness statements. I'm sure this thing takes a long time to figure out, but just based upon the circumstances that and the facts that have come out publicly, particularly the video. Why don't we start with the Renee Good case? And I know, one of the things especially some of my more conservative friends are asking is, well, we want to know, what happened an hour before the video or 5 minutes before the video. And I guess I'd start with, of the things we don't know, like what do you want to know? And does it matter if she was blocking traffic or being, acting in trying to act in a capacity as an activist? Does that matter? Not matter to the situation?
Well, to answer your last question first, given what we know about the case, I don't think it really makes much difference. You're always asking the question, was the use of deadly force reasonable, objectively reasonable? It's not just what this officer thought. It's not a subjective analysis. It's what would the objectively reasonable law enforcement officer do in that case? But your point is well taken. That depends oftentimes on what's going on before. So, for example, shooting someone who fits the description of someone that just robbed a bank and they turned toward you while making a move from their waistline might be entirely justifiable, where pulling a person over for a traffic stop and they reach to take their seatbelt off and you shoot them might not be reasonable at all, even though the movement is essentially the same. So there is context that has to be put in place. But in this particular case, it's pretty clear that she's, trying to inhibit the law enforcement officers in some way, which means she might be guilty of interference with official acts or some other criminal matters. And if she had simply been placed under custody, arrested, handcuffed, and taken away, nobody'd be talking about it. There'd be a criminal inquiry and some sort of probable cause determination, and she'd have a trial if she thought she was innocent, and it would be the normal course of business. The thing that takes it out of that is, of course, the officer responded with deadly force, and then the question is that justified? Would a reasonable officer have used deadly force in that situation?
And so within that kind of legal framework, how much of it, what standard or what duty is there on the law enforcement official to use lesser options? And, is that just all wrapped up in this idea that it's the totality of it, it's the whole situation. And yeah, if you got a lesser, is there a bridge that gets crossed when you pull a gun, law enforcement pulls a gun, or is it, no, it's all just whether it's reasonable? Like, how does that work?
Well, they used to have what they called the use of force continuum. That was in a lot of, when I first started doing these kinds of cases, that was right in a lot of the policy manuals for different law enforcement agencies. So they'd start out with the use of their voice, making commands, and then it would go to, you'd get to hands-on, and then perhaps baton, and then taser, and then at the bottom would be use of deadly force. They got away from that because it was clear under the law that no officer has to go through the whole list to get to deadly force. If somebody turns and points a gun at you, you have to respond. And so you can skip right to the end. But the rule is, to answer your question, is you have to use the lowest amount of force that will handle the situation. And so you can't use deadly force if a taser would work. You can't use deadly force if simply grabbing the person. And the U.S. Supreme Court has clearly held in Tennessee versus Garner that you can't use deadly force just to stop a person from escaping. Doesn't matter what they're accused of. That is never reasonable. So in the Garner case, the young man was shot in the back trying to climb over a fence. And they said, no, that you can't do that. It is better that a person escapes than somebody gets shot and killed. And so that's the rule.
Yeah. One of the things I've heard in some commentary and some articles was that if she was committing a crime, that law enforcement believed she was committing a crime, let's just say obstructing justice somehow, a law enforcement proceeding, does that change their duty? Because, and I'm not saying that she was committing a crime. I've heard people say that might be a justification. Does that factor in?
Well, it factors in the same way we talked about initially, but not really. You still have to, even if she's a horrible person that just robbed a bank, in the case of using a vehicle to justify the use of deadly force, the officer has to objectively, reasonably conclude that she is using her car as a weapon trying to kill him or seriously injure him or a bystander. And, I've got 3 of these cases pending where the officers kill people because they claim the car was being used as a weapon. And in all 3 cases, the video show pretty much what this one shows, which is it's a person not acting correctly. Nobody out there get the idea that it's a good idea to try to drive away from police officers. It's not, but that doesn't mean they get to shoot you. And it's justified if they're actually using the car as a weapon trying to hurt them. And the other factor that comes into this, and this is just not too long ago, a U.S. Supreme Court case, unanimous, this current court that doesn't agree on much anymore, but they did agree in Barnes versus Felix that what I'm going to call officer-created jeopardy does not justify use of deadly force. There's been case law out there that says, look, you can't go over to somebody's house and they're backing out of their driveway as an officer and you stand behind the car and say, oh, they could run me over. I get to shoot them. So that's officer-created jeopardy. That's not allowed. In the Barnes v. Felix case, the U.S. Supreme Court essentially supported that position. That was a case where a guy was pulled over for parking fines. So they had his license. He's on a highway of some sort. and he's off on the shoulder, and he gets fed up and decides to drive away from the officer. Bad decision, but it doesn't mean you get to be executed. And the officer jumps up on the running board of his vehicle. And then as the guy starts to pull away, the officer's about to go on to traffic at a higher rate of speed, and he shoots and kills the guy. And the circuit court in that case said it was justified because in the 2 seconds before he decided to shoot, he was in danger because the car was accelerating and moving away. And the Supreme Court said, no, you have to look at the totality of the circumstances and whether he created that jeopardy. And you cannot, officers cannot create jeopardy and then use it as a justification for the use of deadly force.
And you're saying that was a 9-0 decision?
That was 9-0 decision from the U.S. Supreme Court.
I don't even remember. I didn't hear about that one, but you don't hear about 9-0 decisions in this current Supreme Court at all.
Yeah, and they didn't decide it finally. So I'm guessing that maybe a few of those justices wouldn't necessarily, if they were deciding the case on the merits ultimately, would agree with the outcome. But they were saying, look, you just can't look at the last 2 seconds. You have to look at the whole reason for the stop, which was parking tickets. I mean, yeah, and the officer's decision to jump on the running board. I mean, did the officer create the position he was in? And I think there's agreement that if you conclude that was what happened, then it's not a justifiable use of force.
So one of the things you talked about earlier was objective versus subjective. So I think what you're saying, but tell me if this is correct. Let's say the officer who did shoot her, he was generally in front of her car. To me, it looked like he made that happen, but let's put that to the side for the second. Does it matter what he subjectively believed was going to happen next in his own mind, in his life experiences and all that sort of thing? Or is it, you say, no, it is only what an objective officer should have done. That's a big distinction. Which is it?
Well, because certainly we're gonna want to know as we go through discovery and try to find out what happened, what this officer was thinking about. But the standard to be applied to whatever his thought process was is, would an objectively reasonable officer act in the same way? And that's all that matters. So the officer could say, well, I thought my life was in jeopardy, but it wouldn't matter if an objectively reasonable officer would come to the opposite conclusion. I can tell you I have a very, very similar case pending, 2 of them pending before the Iowa Supreme Court right now, where vehicles were being claimed to be used as a weapon. In both of those cases, and I think this case in Minnesota, the good case applies here. The speed of the vehicle is clearly no more than 10 miles per hour. And in those cases that I'm handling, part of the evidence I put in is National Highway Traffic Safety Administration analysis of pedestrian vehicle collisions. And it's pretty amazing that all the statistics from NHTSA are that they don't even keep track of pedestrian vehicular collisions under 10 miles per hour because the risk of any injury whatsoever is so minimal. Now, at 20 miles per hour, it goes up to about a 5% chance of some risk. And then at 30 miles per hour, it goes up significantly. By the time you get to 50 miles per hour, it's like 90% serious injury or death. So it's very dependent on speed. And one of the factors I'm sure the Good family will be arguing is that her speed was at a low rate. Even if he did get hit by the car, he wouldn't be hurt, or at least not seriously injured or facing death. And that means he would not have been justified in using deadly force.
I think that's a great point. One thing that when I saw the video the first time, and the question that popped into my brain was, could they have just shot out some tires? Like maybe not even the officer who shot her, which he was right in front, but there was at least one, maybe 2 other officers who could see what's going on, and why not shoot the tire? Now, somebody could say, Pat, I mean, you've seen this thing 10 times. They're acting in the moment. But, from a training standpoint and how do you prepare yourself for these moments? What are your thoughts on lesser measures? They couldn't tase her. She's in a car. But if you were doing a class for law enforcement with this particular case, the Good case, what are some of the things that you might say, guys, here's what we could have done and nobody dies?
Well, policies that I've seen and police practices experts I've talked to would say, yeah, I understand the idea of shooting tires out or doing something else like that. But the risk is so much greater that they would never do that, and they shouldn't do that. They never shoot to, they say, oh, why didn't they shoot him in the leg or in the arm, or, the Old West, we're going to shoot the gun out of his hand. No, these officers, handguns are notoriously difficult to become proficient in aiming, and anything over 25 feet is oftentimes missing. They're trained to not shoot unless they're facing an absolute deadly threat, them or another. And they're trained to shoot center mass. They would never shoot to take the tires out. I mean, particularly in a situation like this, I mean, those bullets aren't going to stop when they hit a rubber tire. They're going to ricochet around. The easiest case in the world would be some bystander happened to be walking by and they started shooting tires off on a car, and they got seriously injured or killed as a result of a bullet ricocheting. So no, that is not something that is part of what they're trained to do. But in this particular case, what they were trained to do, and I believe I saw this online, and you have to be a little careful about what you see online these days, but it certainly looked like official DHS policy where they're saying, look, you have an obligation to get out of the way of a moving vehicle. And this gentleman, who before he fired actually did that from what I could tell, but then he fired anyway because he's firing at the side of the car, kind of through the front window, the first bullet, but then the second two through the side window. And they have to be able to justify that analysis, objectively reasonable officer. They have to be able to justify every single pull of that trigger. And that, that's the way it should be. They have to, don't pull the trigger if you're not facing a deadly threat that you have to respond to.
Well, and also, everybody knows this, but this is the government. This isn't two individuals, and they should have, that we give them authority to use deadly force when it's constitutional. And so, yeah, they should absolutely have a standard, a much higher standard than a citizen would. I want to talk about the Preddy case, but before we do you have an opinion, or would you like to, say something about the good case of, I'd love to be the civil rights attorney on that. I know they already have an attorney, but do you want to conclude, or would you say, well, no, I feel like it's still an open-ended question of whether or not it's a case. And by the way, how strong does the evidence have to be to even win a civil case for that particular family?
Well, you have to have pretty strong evidence. You have to show a clearly established a violation of constitutional principle. For example, one of the cases I referred to, we had it in federal court, and a federal judge in Iowa. I won't bore you with it's not boring, but I won't provide all of the factual context. But the guy's in his pickup truck, and he's blocked in an alley behind his house, stop sticks in front, car behind, and he pulls up and has a collision with a cruiser at under 10 miles per hour in front of him, and another officer on the other side of the alley shoots and kills him. And the federal judge in Iowa found that was a constitutional violation. It was an unreasonable use of deadly force, but he said it was not clearly established. There was no other case that we found that clearly established that constitutional violation prior to this officer engaging in that conduct. And of course, we were a little dumbfounded by that, because sometimes, and there's law out there on this point, conduct is so outside the realm of reasonableness that nobody's ever done it before. And shooting someone for being involved in a collision with an occupied police cruiser at under 10 miles per hour has never occurred to anyone as being a reasonable thought. But that's what this officer did. Now, this judge did remand the case back to Iowa, and that issue is currently before the Iowa Supreme Court on whether that's an assault under Iowa law without justification. And I'm expecting a decision in that case anytime soon. But this case, the Marianne Good case, I mean, the video tells the story, and that's the beauty of these cases. All these officers have or should have body cameras and cruiser cameras, and there's so many other cameras that are around. And 9 times out of 10, that's good for the officers, Pat. I want to make sure people understand when you listen to this, that I've been doing this for 20 years, and my respect for law enforcement officers has actually grown as a result of that. I only get involved when something really goes bad. But most of the time when I look at video, it supports the officer making the decision. And think about it. If you're an officer and you're not violating people's civil rights, which includes 90% of our officers, you want video because it proves you didn't do anything wrong. And I know when I get in a case and they don't want to give me the video, that this is one I better take a close look at because they're trying to hide something. So it's very difficult to win just because the video pretty clearly shows, in my view, an unreasonable use of deadly force. That doesn't mean they're going to win. They have to overcome qualified immunity. They're going to have to come up with a clearly established case. And in fact, I'm in the Eighth Circuit too with Minnesota. That case I just cited from the federal district court might be of some assistance to them, because this judge, prior to the shooting of Marianne Good, this federal judge in Iowa, found it was a constitutional violation. It just wasn't clearly established. So that just occurred to me. It wouldn't necessarily be a controlling precedent. If it had been an Eighth Circuit decision, it would. But it's not a controlling precedent, but it's going to be supportive of their position.
Gotcha. Well, let's move to Alex Preddy next. Kind of break down the what happened there. I mean, it's a very different situation. It just happens to be in the same city with the same ICE, buildup of trying to deport people, et cetera. But kind of break that down factually, and what do you view that as an independent case? What are your thoughts on the Preddy case?
Yeah, it's a very similar type of conduct that the victims are ultimately engaged in, and the justification, of course, is different. There's no vehicle involved, so we're not talking about using a vehicle as a deadly weapon trying to hurt somebody. But the gentleman is armed, and this becomes a very interesting topic because of Second Amendment rights in the United States of America. And typically speaking, those people that might be watching this podcast and concluding that they're on the side of the officers, which is they're certainly entitled to do that. Perhaps the people that think that way also feel very strongly about their Second Amendment rights, and I've certainly found that to be the case. I have another case that very similar situation. I had a guy walking through a community. He's on an arrest warrant. He's holding a gun to his own head, and they shoot and kill him. And everybody agrees in this 10-minute standoff while he's walking through this community in Davenport, Iowa, he never moves the gun, never once moves the gun. And they shoot him anyway because they claim that he's approaching some bystanders. He's getting within shooting range of them, which shooting range of a handgun is 300 feet. So he's in shooting range the whole time of the incident. But I thought we were going to win that case. And the federal district judge threw it out on qualified immunity grounds and said, even though we're agreeing he didn't move the gun because he took aggressive action in terms of turning to move towards these bystanders, that an objectively reasonable officers could have seen that as an escalation and therefore used deadly force. I appealed that to the Eighth Circuit, and they upheld the federal judge. And I was so upset about that, I went and got my license to practice before the U.S. Supreme Court, and I filed a cert petition, which I've never done before. And it's 1 in 1,000 chance of getting it. My understanding, well, I know this for a fact, that we filed it late last year, and the defendants were ordered to respond. They assigned us a case number. We're 625-660 in Clume versus Davenport. That doesn't mean they've taken the case yet, but we went from like a 1 in 800 shot of getting it, bad choice of words, 1 in 100 chance of getting it, to about a 1 in 10 chance of the Supreme Court actually taking this case up on cert. And in large part, our argument was this guy has a Second Amendment right that he's exercising. He's got a right to carry a gun. And Iowa law and federal law, in my view, is very clear that unless he uses the gun in an aggressive manner, moves it in an aggressive manner, you can't shoot him. And if you could shoot somebody just for, like Mr. Preddy, holding it to your head or having it in a holster on your side, same thing. You have access to a gun, but you can't shoot him unless he actually makes an aggressive movement with the gun. And of course, Mr. Preddy never did that from my view of the video. And in the case I just told you about, the gun everybody agrees it was never moved. And that's an Eighth Circuit case too. So that might come in on the opposite side of that case in this case, the Preddy case, something they'll probably have to overcome. But who knows? Maybe it'll be a 1 in a million chance, and the Supreme Court will take that cert petition, and I'll be watching some really smart lawyer from Washington argue that case next year.
Well, on the Preddy case, let me throw out this as what if it's established at a trial that the reason Freddie ends up getting shot is not because he makes a move for his gun, because it just doesn't look like he does. He's on the ground getting beat up pretty good. I think he just got pepper sprayed. But let's say that kind of gets established at trial, but that what becomes clear is someone screams gun. And so then, I mean, you're a law enforcement officer and you're in a close situation and somebody screams gun. That to me probably means somebody's about to shoot me. Let's say that we don't know what's going to happen. Let's say that becomes the fact pattern and it's pretty damn clear. Is that going to be a good enough offense that I heard gun, so I just started shooting the guy who might have had I don't even know if gun means, it could have been a gun from somewhere else, right? It could have been, there's a gun in the area. What if that's the fact pattern? What do you think happens next?
I don't think just hearing somebody say gun or he has a gun justifies the use of deadly force. And again, if it did, say goodbye to the Second Amendment. I mean, if law enforcement officers can shoot you because you have a gun or they have even a reasonable belief that you have possession of a gun, then we don't have a Second Amendment right to bear arms anymore. And you know, that's a very important right to a lot of people. And you have to, the rule for the law enforcement officers, again, it's objective, is that gun has to be moved and used in some aggressive fashion, or at least reasonably perceived to be moved in some aggressive fashion in order to justify the use of deadly force. And there are cases out there where people haven't even have a gun, where they pull out a cell phone out of their pocket, but it's maybe getting lit, and the officer thinks it's a gun. And would a reasonable officer think so? Then maybe it uses it. There are cases where there's no weapon at all, but where the person reaches towards their waistband or turns in a particular way where the officer it believes they're crouching. It looks like they're turning around with the gun. I mean, they don't have to wait till the gun is pointed right at them. They have to have a reasonable belief that they have a gun and they're going to use it. And again, that goes back into, well, what are we looking for? Is this just a person who we think jaywalked, or do we have a report that a person wearing a red sweater like this person just robbed a gas station down the street with armed? And so you got to put all that into context. But knowing the information that the officer has at the time, not after the fact justifications, you can find out all the nasty stuff you want about that person, but it doesn't justify shooting them unless you reasonably perceive them to be a threat of serious injury or death to you or another. And, you know, I look at that video and I don't see it, but you have to do discovery. You've got to get to the bottom of the facts of the case and try to figure what happened. I would also add that case, to me, the saddest thing about that case, there's everything about it is sad. The first shots, I think they're going to have a hard time justifying that first shot, but the rest of the shots, they fell into what's called contagious shooting. And I mean, the guy's laying there face down and there's 6-8 shots afterwards. Other officers just join in and start firing away. And that's called contagious shooting. And again, every trigger pull, they need to justify that use of force. You get into question of which shot caused the death and all that kind of thing. And that'll be up to the autopsy, to doctors. And, but yeah, it's just a horrible situation. And then those officers that were firing after the fact, after the initial shot, I don't know what possibly could be their justification. A guy laying face down on the ground. Hard to figure, but again, they have qualified immunity that'll have to be overcome. And these officers, we give these officers a badge and we tell them go out and enforce the law. And that includes doing something that you and I might get arrested for if we grab somebody. It would be an assault, and we tell them that's part of their job. So we have to protect them when they're doing that, reasonably so. And the good news is most of our officers are out there doing their job without violating civil rights. That's been my experience. The bad news is that, in the ICE situation, we have kind of a whole force that may be being trained and actually getting supervisory direction to do things in violation of people's civil rights. And if that comes out, ultimately, we could also potentially civilly hold those people up the chain of command liable for making and providing those orders and implementing that policy. That's the Monell case from the U.S. Supreme Court that allows supervisory responsibility if there's a pattern, practice, policy, or ratification of the wrongful conduct.
Well, and I actually ran into a hard break here, and there's a couple things you just had in that last part that I want to dive into. But look, we're going to do that in part 2 of this episode. I hope that I got a ton out of this podcast on what's going on in Minneapolis. But I'm going to conclude this episode, and I want to thank Dave for being on, and he'll also be on next week for those that listen to every episode. But for this week, I want to thank the audience for listening to the POV of POB.